Historically, one of the greatest barriers to civil rights for people with disabilities has been institutionalized segregation. Even after passage of the Americans with Disabilities Act in 1990, segregation remained a pervasive problem. People continued to be isolated in institutions where they often had little or no access to society at large. Then in 1999, the state of Georgia denied two women, Lois Curtis and Elaine Wilson, their request to move out of state-operated institutions and into communities of their choosing. The women took their case all the way to the United States Supreme Court, where the final decision became known as Olmstead. On June 22, 1999, the Supreme Court, ruling in favor of Lois and Elaine, determined that unjustified institutionalization is itself discrimination.
One of the rationales for why they thought it was discrimination to needlessly institutionalize people with disabilities is that it perpetuates stereotypes and assumptions that people with disabilities are incapable or unworthy of participating in mainstream society. And the Supreme Court got that.
Yeah, freedom.
Why do you talk about freedom?
Because you do a lot of artwork.
Yeah. What does freedom mean to you?
Something that you know about your life using the amateur.
For many, the Olmstead decision became the Brown versus Board of Education for people with disabilities. Separate can never be equal, whether the segregation is by race, disability, or any other type of identity.
You're going to show us around your home?
Yeah, I'll show you my home.
How do you like how long have you been there?
I've been there 3 years.
How do you like it?
I like it all right.
When Olmstead was decided, Illinois was one of the most institutionalized states in the country, ranking 50th in providing services in integrated settings to people with developmental disabilities.
Why is it that other states have been able to move people out of institutions and let them live full lives in the community, and why has Illinois continued and persistently fought that national trend?
Last year, on the 5th anniversary of the Olmstead decision, 13 disability rights organizations sent a letter to the governor, again reiterating our concerns about the lack of community integration services for people with Illinois and the continued institutionalization, and asked for a meeting with him to discuss this. We did not get a response to our letter.
After 5 years of inaction from Springfield and an unresponsive governor's office, Equip for Equality partnered with Access Living and the ACLU of Illinois to file 3 class action lawsuits. The first case, called Ligas, was brought on behalf of people with developmental disabilities living in large facilities, along with people living at home desperately seeking to avoid institutionalization.
I think I want to become a mechanic. Change the tires on the bike. I got the money for gas between power shower.
How long have you lived here?
18 years. September 2nd.
The second suit, called Williams, was brought on behalf of people with mental illness living in large facilities called institutions for mental disease.
The institution I was at, the IMD, had no incentive in having me get better. They had every incentive, as long as I was there, and not too much of a problem. They got paid $130 a day to have me there. If I got better, they would have to replace me.
The third suit, called Colbert, was brought on behalf of people with mental illness and physical disabilities living in traditional nursing homes.
I knew when I got there that I wasn't going to be able to do the things that I wanted to do, like go out, visit my family, friends, eat what I want, go where I want, and just do the normal things that I did before I acquired my disability.
With support from pro bono attorneys at Denton's and Kirkland & Ellis, we negotiated consent decrees in all 3 cases that would systematically provide opportunities for thousands of people with disabilities to live in the community. In the 20 years since Olmstead, Illinois has seen many successes. Thanks to the 3 consent decrees, nearly 9,000 people with disabilities now live and receive services in the community. Additionally, Equip for Equality's Abuse Investigation Unit compelled Illinois to close 2 state-operated developmental centers, Lincoln and Howe, after uncovering systemic abuse, neglect, and rights violations. Today, the unit works with the state to monitor individuals transitioning from Illinois' remaining developmental centers into the community. But there is still a long way to go. Thousands of people with disabilities continue to live in institutions throughout the state. Illinois has also violated all 3 Olmstead consent decrees by failing to move the required number of people into the community or by not providing sufficient resources for those who've already moved into the community. We are encouraged, however, by the Pritzker administration's commitment to fully implement Olmstead and to comply with the 3 consent decrees. All of us at Equip for Equality look to the 20th anniversary of Olmstead as an opportunity to reflect on the monumental impact it's had on the lives of people with disabilities, and we recommit to our goal of ensuring that every person with a disability in Illinois has the freedom and supports to live fully actualized lives in the setting of their choice.